All right, let's jump right into this explainer. Because if you're relying on digital evidence, like WhatsApp chats, emails, or call recordings, you really need to know exactly how to protect yourself under India's massive new legal overhaul. The rules of the game have completely changed with the new Bharatiya Saksha Adhiniyam, or the BSA. And look, if you're a self-representing citizen trying to figure out the incredibly complex maze of court exhibit rules, this information is absolutely critical for you.
Picture this. You've got the absolute smoking gun evidence right there on your smartphone. I mean, it's a WhatsApp message that practically proves your entire case. But then, the judge throws it out on a tiny technicality just because you didn't file the right paperwork. It's incredibly frustrating, right? And the crazy thing is, it happens to self-representing citizens every single day. But here's the harsh reality. Under the new BSA, missing a single procedural step means an automatic loss for your evidence. The old days of just printing out a chat log and handing it over to a judge, yeah, those are completely over. If you don't have a proper legal certificate attached to that electronic record, in the eyes of the court, it is literally invisible. So, here is our game plan for today. We'll start with the digital evidence trap. Next, we'll be decoding Section 63 of the BSA. Then, we're going to look at the massive X versus Y victory. After that, we'll talk about generating valid hash values. And finally, we'll go over crafting your very own self-certificate.
Okay, Section 1. The digital evidence trap. Navigating the new law.
So, looking at this, you can see how courts now demand a really rigorous, step-by-step process of appreciation. They want identification, preservation, collection, examination, analysis, and reporting. They won't just glance at a screenshot on your phone anymore. They want to know exactly how that data was handled from the exact second it was created all the way to the moment it entered the courtroom. It's all about proving it hasn't been tampered with.
We've officially moved away from the old, honestly pretty confusing Section 65B of the Indian Evidence Act to the highly structured Section 63 of the BSA. The old law was notorious for generating huge amounts of litigation just over vague procedures. But the new BSA? It demands absolute technical proof. We're talking mandatory certificates, objective digital hash values, and strict accountability. It definitely raises the bar, but you know what? It also gives us a much clearer path to actually follow.
Moving right along to Section 2, Decoding Section 63 BSA, What the Law Demands.
To even get your foot in the door here, you have to prove 4 baseline conditions. First, the device that produced the record had to be in regular use at the time. Second, the information was regularly fed into it during the ordinary course of your activities. Third, the device was actually functioning properly, or at least if it wasn't, the malfunction didn't mess with the data's accuracy. And lastly, you have to show that the information you're presenting is an accurate derived record.
Now, the new law outlines a dual certificate framework to prove all of this. It asks for one certificate from the party, so that's you, the device owner, and another one from a technical or digital forensics expert. But wait, here is the burning question if you're representing yourself. Do you seriously always need to hire a pricey professional expert just to submit a basic WhatsApp screenshot?
Well, that brings us perfectly to Section 3, the X versus Y victory, power to the citizen.
This quote right here is a total game changer for the self-representing citizen. Justice Ravi Chimalapati explicitly ruled that a self-certificate provided by the petitioner is legally admissible and generally sufficient. That means you, as the device owner, can actually self-certify your own evidence as long as it's coming directly from your own phone.
So why does this specific ruling matter so much? Well, in this case, a husband was trying to submit his own WhatsApp statuses and emails during a divorce proceeding. The trial court actually rejected them, demanding a certificate from some outside proper authority. But the High Court struck that right down. They ruled that if you are in lawful control of the device, hey, you are the proper authority for that device. This explicitly covers your screenshots, emails, and photos. And the best part? It brilliantly saves folks from paying exorbitant expert fees just to tell the judge what they already know.
All right, Section 4, Generating Valid Hash Values, your digital fingerprint.
So, what even is a hash value? Just think of it as a digital fingerprint for your file. It's a code generated by mathematical algorithms, usually MD5 or SHA-256. The real magic of a hash value is that if literally one pixel, one space, or one single letter of your screenshot changes, this alphanumeric fingerprint changes completely. It is a completely objective technical way to alert the court if someone has been tampering with the evidence. So how do you actually get one?
Honestly, if the file isn't highly sensitive or confidential, you can just use AI. You just go to ChatGPT, Upload your evidence file and ask it for the MD5 or SHA-256 hash value. It'll instantly spit out the output. It really is that quick and easy. Of course, just be super careful not to upload any highly sensitive personal data to third-party websites, right?
Now, for sensitive, confidential court evidence, you can safely generate this digital fingerprint entirely offline using your own computer. If you're on a Windows machine, just go to Start, hit Run, type CMD to open the command prompt, and use the built-in Windows hashing commands on your specific file. You just note down that securely generated value and boom, you are completely ready for court.
Finally, we have Section 5, Crafting Your Self-Certificate, the ultimate checklist.
You might want to literally take a screenshot of this slide. These are the exact mandatory details you got to fill out on the required schedule format under Section 63. You need the make, model, color, and serial number of the phone or computer. You got to include unique identifiers like the IMEI number for phones or the MAC address for laptops. You absolutely must include the hash value and make sure to state which algorithm you used. And finally, sign it, date it, and put the location. Do all of this and your WhatsApp chats are legally authenticated.
Now, here's a really cool workaround or ultimate hack based on the famous Arjun Pandit's Supreme Court precedent. If you physically bring your original smartphone or laptop right into the courtroom and produce it as evidence, you might actually bypass the certificate requirement entirely. The certificate is generally just required for copies of electronic records, so bringing the primary device itself is a fantastic shortcut. Also, just to add some context on how courts are treating this in the real world, we are seeing them really adapt to modern life. Recent Supreme Court rulings show that in matrimonial disputes, family courts will often accept relevant digital recordings, even secretly recorded spousal conversations, just to find the truth. The courts have noted that the core objective of the Evidence Act is to facilitate the discovery of truth, and they'll actually override strict claims of absolute spousal privacy when that electronic data is the very best available evidence.
So let's wrap this whole thing up. The new Section 63 of the BSA really doesn't have to be a trap. In fact, it can be your shield. You clearly don't always need an expensive expert to win your case. As that X versus Y ruling showed us, the power is very much in your hands as a citizen. So arm yourself with this knowledge of self-certification and hash values, step confidently into that courtroom, and let your digital evidence speak for itself.